All right, thanks everybody for joining us for our webinar today on special needs planning. We're going to allow just a couple of minutes to continue to admit people to the webinar. So I'll ask everybody to be patient as we're continuing to admit folks to just hang out for a couple of minutes. We just want to make sure that everybody that is trying to get in gets in, and then we'll jump right into it and get started. So again, everybody, thanks for your patience. We'll give a couple of minutes while we continue to admit people to the webinar. All right, for anybody that just joined the webinar, thanks again for attending today. I'm asking everybody to please be patient while we continue to admit folks into the webinar. We're going to let that go on for just another minute or two, and then we'll jump in and get started. So again, everybody, thanks for your patience while we continue to admit folks to the webinar. All right. Again, everybody, thanks for your patience. We're continuing to admit folks to the webinar, so I'm going to ask you to hang tight just for another minute or so while we continue to admit people into the webinar, and then we'll get started. So just another minute or so, and thanks again, everyone, for your patience. All right, everybody, we're going to get started in just a moment. Thanks again for your patience while we're admitting people to the webinar. Again, thank you for taking the time to join me today to talk about special needs planning. Again, we're going to allow just another minute or so to continue to admit folks into the webinar, and then I'll get started. So thanks again, everybody, for your patience. Just about one more minute, and then we'll jump in. All right, everybody, I think we are just about to get started here. Okay. Thanks everybody for being patient with me while we were continuing to admit folks to the webinar. Thanks for taking the time this afternoon to learn about estate planning for families that have loved ones with special needs. Appreciate you joining us today, and let's just go ahead and jump in. So again, thanks for joining. We do have some special offers that I'll cover at the end for anybody that needs to get their planning done and has a special needs family member that they're trying to plan for. We're going to talk to you about that, how that works, what the process is like. And we do have some discounts that we share with anybody that attends our webinar. So again, thanks for taking the time and for joining me today. We are going to be talking about a number of different things. So our agenda is to go over what special needs planning is, what happens if you don't plan, how trust and insurance can be used to protect government benefits. We're going to go over different estate planning tools, a few real life examples from my legal practice that we're going to go over and show you how these things work in real life. And then we'll talk about next steps for anybody that's actually ready to take action and get planning done for their loved ones. So real quick, who am I? My name is Mike Monteforti. I'm an estate planning and elder law attorney with an office in Woburn, Mass. I specialize in elder planning and special needs planning. This is what I do every day, and it's something that I'm passionate about and really love to educate people about. So again, thanks for taking the time and joining me today for this. Going to make sure that we give you some real value for taking the time and coming to listen and share with us today. So very much appreciate your attendance. Real quick. Do you have a plan in place for your child's future? Do you have any type of estate planning in place for your special needs loved one already? And we actually put a poll right into the Zoom, so you can see that there is a poll there that asks about whether or not you have a plan, and there are a couple of different options there. Love you to take a minute and go ahead and answer that question as to whether or not you have a plan in place already. And if you don't, I'll tell you right now, you're not alone. Do not feel bad. Everyone, and I mean everyone, procrastinates when it comes to this stuff. It's normal. It's something that everybody does. So there's no shame here if you don't have a plan in place. You know, our goal is to help you see what next steps look like so that you can actually go ahead and take action on this. So let's move on and jump kind of into the presentation and talk about traditional planning, right? Why do we have to do anything different for individuals with special needs? Why is traditional planning not enough? Well, there are lots of reasons for that. And, you know, our loved ones that have special needs or different needs can have very different financial requirements for them to live their lives. All right. There might be medical expenses, living expenses, special educational expenses, all of which can be all well and good while mom and dad are still around. But if something happens to mom and dad, then what? All right. How do we take care of our family member when we're not there to do it ourselves? So your standard will, you know, your last will and testament, that alone is not enough, not even close to being enough to plan for someone with special needs or different needs. Inheritances can actually do more harm than good when it comes to leaving money to someone with special needs. And we'll talk a little bit more in detail about that. But if you draft a will and you say, hey, I leave all my money to my kids, and one of those kids has special needs, we can actually hurt them by doing it that way. And that's something we really want to avoid. We're going to talk more about that. You need the right legal tools. All right. So if all that you have is a will and that's it, I'm telling you that you do not really have a plan that takes care of your loved one with special needs. You need the correct legal tools in order to do this and do it right. So what is special needs planning? Well, it's a number of different things. In many cases, we're talking about planning for lifelong care. And of course, there are different levels of and different degrees of special needs. We've got folks that have some special needs, but can certainly go out and live their lives independently. And then we've got degrees of special or different needs where we know that our loved one is not going to be able to go out and live independently and are going to need some sort of care for their entire lives. And so it's kind of those two extremes and everything in between. So special needs planning is planning for that lifelong care, making sure that our loved ones have what they need after we're gone. The other thing that special needs planning does is it preserves government benefits that our loved one may be eligible for. And you might say to me, well, Mike, you know, we make too much money, so our special needs child isn't eligible for any benefits. We don't, so why do we have to worry about preserving them? Well, you have to think about, sure, you might not be eligible for any benefits while you're here, but what if something happens to you? What if mom and dad pass away suddenly? Well, now all of a sudden, your special needs loved one doesn't have that income anymore, doesn't have mom and dad there to take care of them, doesn't have mom or dad's income there to take care of them. And at that point, a whole new door can open that includes government benefits for living expenses, for health insurance, and for many other things that they weren't eligible for while you were alive, but now they become eligible for if you pass. However, if we leave them money directly and we leave them an inheritance through a will, uh, they're going to lose their eligibility for many of those benefits. Again, special needs planning can apply to folks with autism. It can apply to folks with chronic illness. It can apply to folks with Down syndrome and any number of issues that require, a lifetime of care in some shape or form. And so people ask about the costs of planning, the costs of not planning, what it looks like, how it works. And I will tell you that the costs of not planning far exceed anything that you could possibly spend in planning and putting a plan together for your special needs loved one. The costs of not planning are absolutely extraordinary. You can cause your special needs loved one to lose government benefits to the tune of hundreds of thousands of dollars lost. Without planning, the court often has to get involved in order to help set up who's going to take care of our special needs loved one and how that care is going to work. The court process is lengthy, it's expensive, it's arduous. And the other thing is that the court makes the decisions. We feel like it should be your decision who's going to take care of your child or other special needs loved one if you weren't here anymore. We don't want the court deciding, we want you making that decision. And the only way to do that is through planning. And without planning, we leave just a road filled with stress, confusion, and a mess. People don't know what to do. They don't know what steps to take, how best to care for the individual with special needs, and they don't know how they're going to pay for it. Where's the money coming from? What am I supposed to do? And the last thing we want is leaving our special needs loved one in worse shape because we're gone. And we don't want to leave our other family members with a mess and in bad shape because they don't know what to do and how to take care of our loved ones. So the cost of not planning, pure dollars, hundreds of thousands of dollars easily when it comes to the loss of government benefits. But beyond that, we're also talking about the time and the stress involved with going to court and setting this up through the court if you haven't set it up yourselves. And that mess, it's even more of a cost than the hundreds of thousands of dollars we're talking about in government benefits. So our advice that we give to clients of ours is to plan now so that you don't pay later, so that your special needs loved one doesn't pay and your other family members don't have to pay. And so what does that look like? Well, if you want to do this right, you need somebody that specializes in this type of planning and knows exactly how to do it because the rules are very, very specific and strict when it comes to potential loss of government benefits. So it's very important that we plan and that we plan the right way. Like I said, if all you have is a will, you don't have a plan. So what does this cost? Well, it's really difficult to give specific costs to people because these things are customized. And so it's almost like asking your doctor to give you medication before they've had a chance to diagnose you. In other words, I don't know what medicine you need until I get a chance to meet you, diagnose your problem, and determine the plan that's going to solve that problem. But giving you ballparks, typical investment for special needs planning can range around $6,000. We provide $500 off for all of our webinar attendees. So anybody that does attend one of our webinars and then comes in and decides to get their planning done, they get $500 off of the cost of their plan. One of the other things that we tell clients is that any amount that they spend for their plan and for a plan for themselves and their children, we guarantee that that plan is going to save you at least 5 times your investment, whether it's in estate tax savings or protected assets or benefits to your kids. That 5x is really on the low side. Most of our clients save closer to 100 times what they spend when it comes to benefits that we're able to obtain and assets that we're able to protect. Our pricing here at my firm is flat rate pricing. There's no surprise billing. There's no hourly work. We charge 50% down payment up front, and the other 50% is due when the work is done. And that fee includes what we call 3-year checkups for life. And that's where you come in and see us every 3 years, 3 years, 6 year, 9 year, and we look at your plan. We look at changes in the law. We look at changes in your lives and make sure that that plan is always up to date. One of my biggest pet peeves as an attorney is when I have clients come in and they bring me trusts and wills and documents that are 20 years old, that haven't been looked at in 20 years, and they haven't heard from their estate planning attorney in 20 years. And the more and more I saw that, the more that I figured out that there had to be a better way, because these documents can go stale. They have to grow with you. They have to change as your family changes. They have to change as the law changes. And how do we do that? How do we make sure that that happens? Is we do these 3-year checkups. It's something that we haven't seen at any other planning firms, estate planning, elder planning, special needs planning in our area. It's something I introduced a while back as a way to make sure that these things stay up to date. So we do include those. It's included with your investment into your plan, and it's free checkups every 3 years for life. So let's talk about a couple of real life cases now. We're going to talk about the Smiths, and then we're going to talk about the Martins. So obviously I've changed the names here due to confidentiality, but the stories here are true. These are two clients that I have had. One came to us and had no planning in place. Those were going to clients we're going to call the Smiths. I'll talk about them in a moment. And then the Martins came to us to put a plan in place, and we're going to talk about the difference between the two. So I had a call from, it was the sister of someone with special needs. She had a brother that had severe special needs, and both of her parents had passed away, not together, but very, very close to each other in time. And so now mom and dad were both gone, and she was trying to figure out how to care for her brother. Her parents didn't have any trust, but they each had an old last will and testament. And I'm talking about 20 plus years old. It was written before the younger brother was even born. And the way that the will was laid out was that all their assets were going to go to their kids and be divided equally. Again, no other planning, nothing specific for the special needs child. And so we've got money going directly to these kids. Well, because the will says what it says, and we've got to give the money to the kids directly, we immediately cost her brother government benefits, because many government benefits are what we call asset-based. Now, not all of them are like this, but a vast number of them are, where if you have too much money, you don't qualify for these benefits anymore. And so we've got this inheritance, goes to this young man, and we have no choice. The will's telling us what to do. We need to do it. And now we've got money in this young man's name, and he's immediately going to be disqualified for any benefits that are asset-based benefits. Next, well, what do we do with those assets? We know we've already lost benefits. How do we deal with those assets for the benefit of the special needs child? Well, we had to go to court and get the sister appointed as a guardian for her brother, which was a whole process. It requires medical testimony. It's something that, again, is expensive and takes time. And the court ordered that we set up a trust for her brother. The problem here is that this trust was set up after mom and dad passed away, not before. So sure, we put money into this trust, and okay, that's great. We can get certain protections from a trust, but we already lost the benefits from the government that we were trying to get. And if putting any of the assets into trust at this point somehow allowed us to squeak in and get some benefits, well, because the money was already in the young man's name, Medicaid, Mass Health, other government institutions that provide benefits have what's called benefits payback, where even though the money's in trust now, because the trust happened after mom and dad passed away, any benefits that we do obtain can be retrieved by those government agencies if the special needs child passed away. So they could come back to the trust and look for a return to them of anything that was paid out on their behalf. So basically, that inheritance that we left them could all completely disappear and end up going back to a Medicaid or Mass Health that paid out benefits for this young man. Let me tell you, the sister was overwhelmed. That word doesn't even describe it. When I first met with her, she was, just in tears, completely unsure of what to do. She was an adult, but a young adult, and all of a sudden was thrust into this position of having to be a caregiver for her brother with no guidance, nothing set up by mom and dad. And now all of a sudden, this becomes a responsibility that she has to take on, and it just completely overwhelmed her. And she was uh, just so sad to see and talk with, because every time I talked to her, I knew she was gonna cry, and it was just a terrible situation that was completely avoidable. So let's move on to the Martins. Again, not their real names. Came in to see me about putting some planning in place for their special needs daughter. And so we talked about, number one, how do we make sure that there's money set aside that's going to take care of their daughter for the rest of her life if anything happened to mom and dad? And in order to do that, we put a trust in place. It's a trust that we sometimes call special needs trusts, sometimes supplemental needs trusts. We'll talk a little bit more about that in a minute. And we put life insurance in place to fund that trust if mom and dad were to pass away. And we use a relatively simple calculation to try and determine what's the cost of the care of this individual going to be, for the rest of their lives. What's that going to cost us? And we use that to determine the amount of life insurance policy for mom and dad to apply for. Term life insurance is very cheap if your health is okay. And we use that to fund this trust so that, number one, we've got money to help take care of their daughter if they pass. And number two, because we're creating this trust while mom and dad are still alive, and the money is going to go directly to trust if they pass away, benefits are preserved. So any benefits that their daughter was eligible for already or might become eligible for later if mom and dad pass, those benefits are going to be preserved. We're going to be able to have money in trust for her to make sure she has everything she needs for her entire life. We're going to also have guardians named for her and backup guardians named as well, so that everybody knows exactly what's supposed to happen and who's supposed to take care of her if mom and dad pass away. And lastly, by setting up the trust ahead of time, we avoid Medicaid, Mass Health, or any other agency from being able to come back and get payback from that trust. Whatever benefits are paid out, they're not going to be able to come back and seek it from the trust and pull that inheritance money out of the trust, like what happened with the Smiths. So you can see very, very different uh, types of situations. And in this case, it was a few years later, mom and dad did pass. Again, it was a sibling, an older sibling, that was taking control and taking care of their sister. But in this case, we had everything clearly mapped out, everything put together to make sure that their money was there that was needed, that the benefits were preserved, and it was just a much, much easier road for this sibling than what we saw in that last case. So the key differences between these two situations, in situation number two, we're protecting the assets, right? We've got peace of mind for mom and dad. And believe me, they were very, very relieved once I went through this with them and explained how we could preserve assets, how we could make sure everything was done the right way, and that no matter what happened to them, their child was going to be taken care of for the rest of her life. This is something that just let them sleep at night much, much better. And lastly, we avoid that Medicaid payback by setting up the trust ahead of time. We can keep Medicaid, Mass Health, or other agencies from trying to get repaid through that trust. And so let's talk a little bit about special needs trusts. Sometimes they're referred to as supplemental needs trusts, and there are a number of different types. There are what are called first-party special needs trusts and third-party special needs trusts. And that first-party and third-party term refers to where the money came from. So a first-party special needs trust comes from the individual's own money, like in the case of the Smiths. He received an inheritance, that money was his, it went into his bank account, and he used that to set up his own trust. Now, a third-party special needs trust is different. That's where the money comes from someone else, like mom and dad, and never goes into the name of the individual. And the key difference between the two is that Medicaid payback. For a first-party trust, where the special needs individual uses their own money to fund that trust, any benefits that they receive, Medicaid and other agencies can seek payback. They cannot do so in a third-party special needs trust because the money never goes into the individual's name. It goes right from mom and dad or grandma and grandpa directly to the trust. It never goes into the individual's name, and that type of trust avoids that payback. There's a third type that are called pooled trusts. They can be used typically use them more for older individuals, especially in the cases of where they need 24-hour long-term care and where they have, again, inherited a bunch of assets from someone that did no planning. So the ideal version here is the third-party special needs trust or third-party supplemental needs trust. So just curious if any of you all, if you want to use the chat, if you do have any type of special needs trust, supplemental needs trust set up already, love to see you take a minute and throw that into the chat box and just say whether or not you have an SNT. And then the bigger question beyond do you have an SNT is it funded? In other words, you might have this trust, but do you have a way for money to go into that trust so that it is preserved and to be able to be used for the care of our special needs loved ones? So if anybody does have that, or even if you don't, you want to throw that into the chat box, whether or not you have that, that'd be great. So let's talk a little bit more about funding these trusts. So the way I explain it to clients a lot of the time is to think of a trust like a bucket, okay? It's a bucket that's empty and it's waiting for money to go into it. And any money that goes into that bucket then gets administered for our beneficiaries in accordance with the trust terms. They have to do what the trust tells them to do. But if we have no way to get money into that bucket, all we've got is an empty bucket, and a really pretty empty bucket that doesn't do anything. So one of the most common ways that we use to fund that bucket is through life insurance. It's probably the most common funding tool. There are different types of life insurance policies that can be used. There can be individual policies or what we call second to die policies. And that's basically a joint policy for mom and dad that they take out together. And the life insurance payout doesn't happen until the second person passes away. So that's why it's called second to die. Those tend to be even cheaper than two traditional term policies for mom and dad. But the idea is to figure out what is going to be the cost of care for our special needs loved one to make sure that they're cared for their entire lives. And that can easily go into the hundreds of thousands of dollars. And most of us don't just have that laying around, but we know that our kids need it. Well, where are we going to get it? Using life insurance as a tool for funding these trusts and be very affordable. Again, term life insurance is pretty cheap as long as your health is good. We figure out how much of a policy to apply for, and we make your life insurance policy leave money directly to the trust so that this bucket that we're talking about receives the money from that life insurance policy. If you pass away, that money is going to pass tax-free. That money doesn't have to go through probate. It's going to go directly into trust, and it's going to be there for our special needs loved one to be able to be used for their care for the rest of their lives. So what other special needs tools or what other tools do special needs families need. Well, it's still important that you have a will. Now, I've said it over and over again that having just a will is not sufficient. That's not going to cut it when we have a special needs loved one. But it's still important that we do have one. It just can't be the only thing we have. Power of attorney. This is super important. This talks about, again, who's going to handle our finances if we can't do so for ourselves. If we have a special needs child that's over 18 and we're helping them with their finances and they do have the capacity to understand and sign legal documents, they can grant you a power of attorney so that you can help them with their banking and help them save money. A healthcare proxy is another super important document where, again, if our special needs child can understand and sign legal documents, they can give you authority to make decisions about their healthcare. So power of attorney and healthcare proxy are super, super important documents if your special needs loved one has the ability to understand and sign those documents. But what if they don't? What if they're not able to understand legal documents and don't have the capacity to sign? Well, in those cases, we look at what are called guardianships and conservatorships. And these are processes that you can go through with the court when your child turns 18 to put yourself in a position to make healthcare decisions for them and make financial decisions for them. Now, it is a process that's done through the court. There are steps that need to be taken, and it is something that takes time, and there is certainly an expense to it. But this is what allows you to make decisions on behalf of your child or loved one when they can't do it for themselves and they don't have the ability to grant that authority to you. Now, we've talked a little bit about government benefits and eligibility and what we call asset-based benefits, which, again, in simple terms means if I have too much money, I'm not going to qualify for these benefits, right? They're based on what you have for assets. And there are benefits like SSI, SSDI, Social Security Disability Income. There are Medicaid benefits, mass health benefits. There are even VA benefits. But many of these benefits have asset limits. Sometimes they have income limits as well. They can easily be taken away by the government at any time. They're getting more and more strict when it comes to qualifying for this stuff. They're making it harder and harder. A trust, a special needs trust or supplemental needs trust, can help protect their eligibility for these benefits. Another thing to be aware of, especially if you have a special needs child and they are maybe in their teens, 15, 16, 17, there's a law in Massachusetts, we refer to it as the Turning 22 law. And this law has requirements if the child needs continuing benefits after either they graduate from high school or after they turn 22. And it's a way for you to continue benefits that they were receiving when they were younger and keep those benefits going even after they graduate high school and even after they turn 22. But it's something that you have to prepare for ahead of time. You can't wait until they turn 22 to do it. You have to start that process early. So something to be aware of. Clients that come in to see us start with what we call a strategic planning session. There typically is a cost of $450 for this session, but we provide the session for free for anybody that attends our webinar. So any of you all that have joined us today can book a strategic planning session, and that charge is waived. So it's free for our attendees. It's where you sit down for an hour with me. We'll review your situation. If you have any existing planning, we'll review that planning and we'll give you real answers and recommendations. We'll talk specifically about how any plan that you might have works, what it does, what it doesn't do. Do we need to add to it or is it fine on its own? Do we need to supplement it? Do we need to do things different based on changes in the law and based on how old the document is? So something to be aware of when you come in for that planning session. I guarantee you will get value out of that session because at the very least, you're going to get some real answers and recommendations based on what type of plan you have, or if you don't have any plan, we're going to walk through with you what is going to make sense for you and your family. Again, we do have a special offer for anybody that attends our webinars. Not only do you get the $450 fee waived for your session, but we take $500 off the cost of your plan. But in order to do that, you do need to book that appointment today. And so it's one of the ways that we make sure that the information from the webinar, what we're doing today, is still fresh when you come in for your session. So if you are interested in that and you think that we might be a fit, then book that session. You don't have anything to lose. I guarantee you're going to get value from it, whether we end up being a fit for you or not. But it's really a way to get advice, recommendations on how to secure your child's future. And if we determine that we are a fit, we talk about next steps and how to actually get this planning done. All right. So this strategic planning session is for people that, whether you've been procrastinating or not, are ready to take the next steps and get this done. So final thoughts, what we tell people is to be the hero, and that not all heroes wear capes. If you want to be a hero to your child or your special needs loved one, you need to take action and make sure that if something happens to you, they are going to be taken care of, that they are going to have the money they need for their care, that they're going to have the benefits that they need for their care, and that they've got somebody to take care of them. And so putting a plan together is how we make you the hero of this story, because what you're giving that child by putting and planning together is really is a gift that you're giving them, and avoiding that complete mess and disaster that we saw with that first family that we talked about in our example. So in just a moment, I am going to open up the chat for anybody that has any questions. We'll do that in just a minute. Before that, if any of you have been attending the previous webinars in this series, because this is part of a series of webinars, whether you attended any of the previous webinars or not, our next webinar that we've got coming up is estate planning for modern families, which is including what we call blended families or planning for families after divorce. Because blended families and families where the parents are divorced do require special considerations for their planning. There are a number of different issues that come up. So that webinar is going to be on Wednesday, November 5th at 12. So anybody that's interested in that can sign up. And then this is the QR code for those of you that know how to use a QR code. I tell people I'm a great lawyer, but I'm not necessarily the most tech savvy guy in the world. You can use that QR code to book your session online. Honestly, the easiest way to do it, if you have the time, is to call the office 978-657-7437 and book it that way. But if you just don't have a minute to call and it's easier for you to do it online, you can do it using that QR code, or you can go to our website is bookmyplanningsession.com. That will take you right to the calendar where you can book your hour with me. Again, that hour is at no charge for anybody that's attended our webinar. What I ask that you bear in mind is that that hour really is for people that are ready to get this done and take next steps here. So I want to make sure that we do that Q&A. So I'm going to open up the chat box here. And if any of you have any questions, anything that we did not get to yet, I want to make sure that we answer those. So anybody can feel free to type questions into that chat. Derek, I see here you answered that last question and put that you've got a funded irrevocable trust. So that's fantastic. Depending on the age of that irrevocable trust, I would urge you to get it looked at if it's more than 3 years old. One of the funny things about an irrevocable trust is people often think that because it's irrevocable, it's written in stone and there's no way to change it. That's not necessarily true. There are still many aspects of an irrevocable trust that we can change, and they are typically provisions that have to do with government benefits. And because the law changes so frequently when it comes to that, It's something that is worth having your trust reviewed, which is included in your strategic planning session. I do review the trust. If it's great, I'm going to tell you it's great. If there are issues with it, I'm going to tell you what they are, and we could talk about steps for how we might want to amend if an amend is proper. So let's see. I'm not seeing any additional questions at this point. I'm going to give it just another minute. Like I said, if you're looking to get this done and you're looking to, take next steps to protect your family, I guarantee that you'll get some value out of that session. So if you're on the fence, I would recommend that you book it, do it today so that you don't miss out. One of the biggest things I see is people who don't take the step now and then something bad happens and they come back wanting to try and put some kind of plan together, but for many things we are too late, and in that case the family is left with that mess, and so we want to prevent that. All right, I see one question. What level of competency does the court require for my child to execute their own inheritance? And so this is a little bit of a lawyer question where I'd say it depends. There really is not a standard answer. What we want to know is, does your child have the ability to understand concepts and be able to make a decision on those concepts? And how do we find that out? Most of the time, it's through our medical providers or other care providers for our children. So if I have clients come in and maybe they want their child to sign a power of attorney to them or a healthcare proxy with them, well, I talk with them to see whether or not it's something that they can understand. And if I feel comfortable that they get it, we can proceed with signing. If I'm on the fence, then we would ask one of their medical providers to give us a letter stating their opinion about whether or not they are competent enough to sign documents. What happens to the money in a supplemental needs trust when a special needs person dies? Well, it depends on whether or not you've got a first party supplemental need trust or a third party. So in that case of the Smiths that had no planning, they had a first party supplemental needs trust. If the special needs person passed away, any money left in that trust, Medicaid is going to go be able to take as part of payback to get back any money that they paid out in benefits. However, if we do it right and we plan ahead and we do a third party supplemental or special needs trust, where does that money go when the special needs person dies? Wherever mom and dad want it to go. Maybe it's to go to other siblings, other kids, family members, charities, whatever you want, but we don't have that payback that Medicaid or Mass Health can come and try and take the money out of the trust for. Let's see. My child doesn't qualify for benefits now, but if we pass away, would they qualify if the estate planning is set up correctly? So that's a great question. And absolutely, yes. There are many benefits that your child might not be eligible for because you're still alive. Mom and dad are here. Mom and dad have income. And so mom and dad's income keeps our child from being eligible for these benefits. But if mom and dad pass away and we do planning and the money is going to go into a supplemental needs trust, whether it's inheritance, life insurance, whatever the case may be, absolutely a whole world of benefits can open up for that child, and they won't be disqualified for any benefits that are asset based because those assets won't count against them when they are put into one of these trusts and when it's done correctly. And that is a huge, huge part of it when I say done correctly. This needs to be done by an expert. This is top level planning, something that needs to be done by someone that does this kind of work every day, because there are attorneys out there that dabble in this sort of work. Maybe they don't mean any harm. They're just trying to help out a friend or a family member, and they end up doing more harm than good. This is something that should be done by a specialist, an expert that does this type of work as a main part of their practice. So I don't see any additional questions. So I want to thank everybody for taking the time and for joining me today. Again, if you are serious about taking action and getting things done to protect your family, I urge you to book your planning session now. If you book it today, that $450 fee is waived. So it does end up being a free session for you. If we determine that we're a fit and we're going to put planning together for your family and your child, you're going to get that additional $500 off of the cost of your plan. And so that plan that we're going to put in place is also going to include those 3-year checkups. So you come in and see us every 3 years at no additional cost, and we review your plan, your family, the law, and make sure everything is exactly the way it should and still does what it's supposed to. My last thing I'll make one final ask here for anybody that is planning on coming in to do a planning session, or anybody that even isn't necessarily going to come in and do a planning session. If you got value from the webinar today, we would have really appreciated if you'd be willing to leave us a review and just say something simple like the seminar was helpful or the seminar was informative. If you do book a planning session and leave us a review, we will have a thank you gift for you when you come in for your session. But even if you aren't ready to take steps at this point, but you got value out of the webinar, I'd appreciate you going to reviewmlaw.com and leaving us a review just saying that the webinar was helpful, that it gave you some good information. So with that, I'm going to go ahead and end the webinar. Again, thanks everybody for joining us today. I appreciate it. Thanks for taking the time. I really urge you to take advantage of the free planning session. I guarantee that you're going to get value from it. So thanks so much, everybody. I appreciate it. Have a great rest of your day.